Yes.
Thank you, sir. I had reached the fifth of my 10 sections. This is entitled The Transfusion of Blood. Much of the investigation which was undertaken by the inquiry and the focus of its oral hearings have been on the causes and effects of the blood contamination disaster on those who suffered from bleeding disorders. By far the most numerous group of infected and hence affected people is amongst those who acquired their infection by blood transfusion. In our submission, sir, we recognise that there are perhaps difficulties relating to the identification of themes and trends and systemic failures in the transfusion community, given the diversity of circumstances in which people were infected. However, our conclusion, which is to be found at section I of our written submissions, is that a number of important themes emerge. I should say, sir, that the tenacity of the campaign led by those predominantly from the bleeding disorder community and the disparate nature of the circumstances of the transfusion infections has, in our submission, led to them often having no ready-made association or means of organisation. On occasions, this has meant that the plight of those who are infected by transfusion being marginalised in the media or by government. In our submission, this must stop. They have suffered similar consequences and they have been exposed to the same tragedy. As regards the transfusion infections, we argue that a careful analysis of the available evidence does allow clear conclusions to be drawn. Our analysis of the evidence concludes that the deficiencies in the way in which blood services operated in Scotland caused multiple unnecessary infections with both HCV and HIV. The evidence to which I referred earlier, presented to the inquiry by the statistics group, shows that this had a real effects and caused unnecessary infection. The group commented specifically on the fact that the number of HIV infections from transfusion in Scotland was disproportionately high when compared with the rest of the UK. Dr. Gillan, who carried out the Scottish HIV look-back in that community, explained to the inquiry that this was likely to be a minimum number of infections, namely 18, caused by that route. There are, of course, limitations of the look-back procedure in general, and we suggest in our submission that the fact that its reliance on repeat donors may well mean that that number is in fact higher. In our submission, sir, the number of HIV infections in that community indicates the effects of the poor blood collection and processing practices to which I've already made reference. This is supported in our submission by the evidence available in the Crawford paper from 1991 and the statistical analysis undertaken by your statistics expert group, which suggests that in the HCV population, there was a higher rate of infectivity in donors in Scotland. Although this will in part be due to the fact that there was a higher infectivity in the general community, based in their assessment on higher rates of intravenous drug use. Mr. Bowie accepted that there had been insufficient efforts to exclude those donors, and in our submission, these higher rates of infection result directly from the practices which I've already outlined. We have also in our submission, sir, conducted an analysis of documentation relating to transfusion practice, by which I mean the actual delivery of the blood transfusions. These reveal that blood was transfused unnecessarily, and at times the profligate use of blood and blood components in Scotland was evident during the period of infective risk. The evidence presented by our clients also reveals that blood was generally transfused with little or no regard to the views of patients. Informed consent about risks or reasonable alternatives, frankly, did not feature at all. You will recall, sir, the evidence given by both Dr. Keel and Dr. McClelland about a much later initiative to try to regulate the use of blood in Scotland, which in particular, you may recall Dr. McClelland speaking about his surprise that he found a cardiac surgeon, I think in Portugal, who was able to carry out certain procedures without using any blood at all. But those processes, sir, which took place many years later, are indicative of the fact that the system had been profligate for many years, that unnecessary transfusions were given. The practice of top-ups, which we heard about across the country, was also a feature of the Scottish evidence, and that therefore risk of infection was increased unnecessarily. We have also, sir, conducted an analysis of the look-back in relation to HCV. As I've already mentioned, the practical impediments which were identified by Mr. Corey Wright with regard to the difficulties which the predecessor of NHS-BT had in knowing what happened to the blood that they collected were not impediments which generally existed within Scotland. Dr. Keel, when asked about look-back, pointed to the west of Scotland, where she illustrated the difficulties in this regard by the fact that the West of Scotland Transfusion Centre was situated at Law Hospital in Lanarkshire, rather than in a hospital. It was interesting in our submission that she chose that particular example because that was the only one of the transfusion centres in Scotland which was not effectively based in a hospital. And Dr. Gabra, who spoke on behalf of that service, made it clear that one of the first tasks with which he was charged when being engaged by the service was to improve the connections with hospitals. As a result, therefore, sir, our conclusion is that the transfusion service could and should have done more both to advise those using blood in transfusion in hospitals as to its risks, but also that the suggestion of there being practical impediments to the look-back were in fact illusory, prevented only by poor practice in record-keeping and the government's culpable unwillingness to find those who might blame them for their fate. Dr. Gillan was, of course, the king of the look-back in Scotland. He stressed the important advantages of doing look-back as near as possible to the time, which was why he felt that the HIV look-back conducted by him in the mid-80s was perhaps more reliable than the HCV one that he did not undertake until later in the 90s. Delay was predictably fatal to the utility of the project, which was already limited in its scope due to its reliance on repeat donors and the considerable limitations of record-keeping. As a result, many infected patients in Scotland were lost. Epidemiological analysis undertaken by the Statistics Group estimates that at least 2,500 people were infected with HCV in this community. The approach was, in our submission, redolent of an insurance company seeking to minimise its financial liability, rather than the state in a democratic society with its clear legal and moral obligations to protect those individuals whom it has infected. The effects of this indifference are plain, we say, from the evidence you have heard. The inquiry heard from those who were not found. One client of ours, sir, I must unfortunately inform you, who gave evidence, who was from this community, who gave oral evidence in 2019, has since passed away. The inquiry also heard from those who were found. Many have told in their evidence of the matter-of-fact way in which they were informed, with no apparent realisation that many of them had had no reason to have any contact with health services and no ready-made place to go for help. They were thrust into a world of liver clinics populated by those who would be infected by IV drug use or other means. They were regularly stigmatised and traumatised by medical staff who assumed they were drug abusers or alcoholics. Many did so completely alone, thinking unnecessarily that they were the only ones to have suffered this unimaginable fate. Sir, before moving on the subject of look-back, I would also just like to draw your attention to another couple of elements of it. Although, of course, the main thrust of our arguments about the failures of look-back relate to the failures in finding people who were infected by transfusion. The evidence in Scotland suggests that during the course of the Scottish Executive investigation in around 2000, Doctors Ludlam and Lowe brought to the attention of the investigating civil servant Dr. Keel that there may in fact be people from the bleeding disorder community, mostly mild patients, who may have been infected who are not traced. We've drawn attention, sir, in our submission to a meeting in 2000 where this happened. Our understanding is that despite those warnings, no efforts were made until many years later to locate those individuals. Indeed, Dr. Keel, in her oral evidence, was taken to another place where Dr. Ludlam had at one stage attempted to inform the state that there were possibly infected individuals who had not been found. Dr. Ludlam pointed out that there were patients who had received Scottish factor IX concentrate for medical matters other than bleeding disorders. In her evidence, remarkably, Dr. Keel suggested that such patients may number in the tens of thousands. Some of those will have been exposed to factor IX concentrate before heat treatment of the product in October 1985. No efforts appear to have been made to find them. Sir, I'm moving on to my sixth topic now, which is what we call the domino effect, patients as people and as pioneers. Like Mr. Snowden, our extensive review of the evidence available to the inquiry from our clients is that not a single one spoke to having been advised of the risk of viral infection from blood or blood products. In our submission, we present an analysis not only of the ethical guidance of today, but the long-standing ethical guidance of the time. The lack of informed consent to treatment and testing, the failure to inform patients of their diagnosis and to provide anything like adequate support to them when they did find out, represent in our submission a system-wide abrogation of the state's ethical responsibilities to patients on what, to my knowledge, is an unprecedented scale. It should, in our view, be borne in mind that many of the patients infected were not infected in acute situations, though some were. The long-term care of bleeding disorders and other chronic conditions which required transfusion, as well as elective surgery and the ability to plan an approach to obstetric emergencies, lent themselves to patient interaction and careful planning in the interests of safety and autonomy. This simply did not happen. In our written submission, we describe in some detail, based largely on a wide review of the evidence from the Scottish community, of a kind of domino effect from not telling the patients about the risks involved in treatment, which is apparent from the evidence. Having not been involved in decision-making at the start, that locked the clinicians into a position. They committed to the products being safe, in some places like Edinburgh, despite direct questioning to that effect by the patient. That then led to difficulties in revealing other matters, such as the fact that patients were involved in research or that risks had begun to emerge. It created difficulties with informing patients about the fact they were being tested. Why would they be being tested if they had been told the products were safe? Once the terrible reality of infection became apparent, it was obviously difficult for doctors to reveal that reality to patients. However, it was done completely inadequately. The December 1984 meeting in Edinburgh, to which my learned friend Mr. Bowie made reference, represent the ham-fisted attempts of a medical community trying to deal with the terrible reality of their patients' infections against a background of them having failed in the first place to inform the patients about the risks. Sir, one thing I would like to point out, which is of some significance to us, is that in this regard one sees in many documents, both from factual witnesses and from those who are assessing that evidence, the reference to the concept of paternalism. This is a good example, sir, of the phenomenon that I described earlier, of the medical profession simply seeking to say that something happened across the board and therefore it was acceptable. Paternalism, sir, might be described as thinking or behaviour by people in authority that results in them making decisions for other people that, although they may be to those people's advantage, prevent them from taking responsibility for their own lives. It seems to be trotted out as a party line, a defence against allegations of widespread ethical breaches in this area, as if the defence of "we all did it" in the pre-Blytho era is a good one. In our submission, sir, although there is a similarity between the word paternalism and paternalistic and paternal, the two things are quite different. Paternalistic relates to obviously they come from the word pater in Latin, meaning father. Paternalistic relates to the authoritative element of a father. However, in essence, in our view, paternalism was and is unethical. There was nothing paternal about the way in which many of our clients were treated. In our submission, sir, there was unethical medical practice revealed on a large scale. In this regard, sir, although I've suggested that I don't intend to make reference to the conclusions of the Penrose inquiry, I think I need to. The conclusions of the Penrose inquiry in this regard are in our submission, instructive as to the importance of this area and certain pitfalls that need to be avoided. The inquiry was assisted in this regard by two expert witnesses, namely Professor Nathanson and Professor Hay, former chair of the UK HCDO, from whom this inquiry also heard. Though the latter was not a clinician who worked in Scotland, he was, in our view, clearly not an independent witness. In paragraph 32 of the report, the position which is adopted or accepted generally by the Penrose inquiry is that before 1988, there effectively were no ethical rules relating to the matters to which I've made submissions. It suggested that the conduct of medicine before that time was a kind of ethical Wild West, where there were no rules to which adherence could be expected. In our view, this approach is flawed. It is not consistent with the evidence of guidance at the time. It conflates factual evidence of the lack of regard for patient autonomy with the separate issue of what the ethical approach ought to have been. The evidence before this inquiry, as others have suggested, constitutes a clear basis on which contemporary ethical standards were institutionally disregarded. This applies to all types of patients in our submission and is a sound basis for the conclusion to be reached that there is a moral duty on the state to its patients which was breached in relation to informed consent, testing and other matters. As a result, sir, it is an important part of our argument that there is a moral duty for the state to pay compensation in this regard. Sir, I've already touched on research to a certain extent, but I do feel, as it's an important matter to many of my clients, that I'd like to say something further about it. I do so in particular in regard to an observation made by the NHS Scotland submission, which I feel I have to address. The suggestion made by Mr. Bowie in his written and obviously referred to in his oral submission was that one of my clients in her evidence suggested that there had been deliberate infection of patients in Edinburgh with HIV. In our submission, sir, we make it clear that this is not our assertion. We present a detailed analysis which leads to the conclusion that the Edinburgh patients, those who are still alive, formed the view in our submission quite reasonably based on an extensive analysis of evidential material that came available to them after the event, that it was possible that something had happened to that effect. They do not assert that it did, but it is in our position important to realise that a significant part of the compounding of their harms has been based on the fact that they were, throughout the relevant period, kept in the dark. When they asked for explanations, they did not give them, they did not receive them. And in circumstances where an extensive evidential search was done by one of my clients, Mrs. Mackey, who also gave evidence to the inquiry, she reached the view in our submission quite reasonably that that may have happened. Now, sir, I won't get into the detail of that today, but there is a very detailed analysis of the reason why, in our submission, she and her husband and many others were driven to that conclusion. Research in Edinburgh, and not exclusively in Edinburgh, because a significant amount of research also took place in Glasgow, was an essential part of the system of the treatment of haemophiliacs. My client, sir, Mr. Norval, asked the question at the end of his evidence, what are haemophiliacs for? It would be impossible, in my view, to come to the conclusion that research undertaken on haemophiliacs, who willingly offer up their arms and their blood in their evidence for the checking of their factor levels, have not been subject to research on a grand scale. In his submission to the inquiry, Mr. Cummins, in relation to the treatment of the boys at Trelawney, said that his clients had come to the view, based on the evidence examined by this inquiry, that research had been undertaken on them which was not in their interests, but for the interests of others. I can well imagine why they have reached that conclusion, and the same conclusion has been reached by those who were involved in research in Scotland. The Edinburgh research agenda, sir, started almost as soon as Dr. Ludlam arrived. A letter was written to Dr. Krask by Dr. Ludlam on the 28th of April 1980, shortly after his arrival at the centre. The reference is LOTH 5031_27. In the interest of time, sir, I'm just going to refer to its text. The context of this is Dr. Krask inviting Dr. Ludlam to become part of a working party on hepatitis. And this is the reply. He says, Dear Dr. Krask, thank you for your letter the 28th of March. I apologise for the delay in replying, but I was away the first half of April, and since returning several of the people I wanted to consult before replying to all the points in your letter, I now find our away from Edinburgh for the next week or two. Since it is a month since you wrote, I thought I should commit as best I can for now and give a more definitive reply shortly. Thank you for your invitation to serve on the working party. I am very happy to accept your kind offer. Like most clotologists, most of my training has been in the treatment of haemophilia from the bleeding point of view, and I have relatively little knowledge of hepatology. This, however, is obviously an increasingly important area. I am anxious to learn, and I hope I may be of some help to the project. I am very conscious of the almost unique group of haemophiliacs we have in Edinburgh, because they have never received commercial concentrate. They are therefore, as you are aware, useful material for a variety of studies in relation to liver disease. There are various pressures working against keeping our patients free of non-NHS concentrate, but I am doing my utmost to resist these. I think that the liver biopsy project is very worthwhile, and I hope to be able to contribute patients to this. Sir, in our submission, this forms important context to the breakdown in relationships between the Edinburgh patients and their consultant, Dr. Ludlam. The unique circumstances of the Edinburgh group went on, of course, to become why it was that they were described as one of the most extensively studied group of HIV-infected individuals in the world. The research which has been undertaken is in our submission, instructive about the causes of infection and other matters which are relevant to the inquiry's remit. They reveal that infection with concentrates in Edinburgh was more likely to occur in circumstances where people were exposed to more product. As I've already said, in the period under examination, the amount of product used compared to the second half of the 1960s rose by 6 times.
The second half of the 1970s?
Sorry, compared to the second half of the 1970s, rose by 6 times. That's correct. Sorry, sir. The position, sir, therefore, is that as a result of the information becoming available to patients subsequent to infection, the role of research has, in my submission, become quite reasonably part of their analysis of what the motivation was for why they became infected. As the boys from Trelawney have put it, my clients have become of the view that extensive research in the interest of others was prioritised over their safety. They continued to be exposed to concentrates, which the immune studies in 1983 showed were harmful, if not infective. They showed that they affected immune function and therefore exposed patients to greater risk. Despite this, sir, the study continued, and in my submission, the conclusions which were reached by those who researched the position, having been left in ignorance by their consultant, were entirely reasonable. These concerns were added to, sir, by the way in which the December 1984 meeting was handled. You'll remember, sir, that Mr. Bowie, I think, accepted, quite rightly in our view, that the way in which that had been handled was unacceptable. And on that particular occasion, my recollection was that his client's Lothian Health Board, I assume, accepted corporate responsibility for the failure to engage in that. A general point I would make in that regard, sir, is one I've made already, that it's slightly odd, it seems to me, that they would accept corporate responsibility for that and not other things, but the concession is certainly appreciated. You are aware, sir, that in the aftermath of that meeting, patients having reasonably arrived at the conclusion that they must not be infected, otherwise why would the possibility of infection have been revealed to them in those unusual and unacceptable circumstances, that an advice leaflet was sent to the patients. That advice leaflet can be found at PRSE 0002785, and the particular page is the final page, which is _0003. The final page of the advice sheet sent to the patients in early 1985 contains the statement that as of now, all factor VIII concentrate is being heat treated to destroy the virus. You will be given heat treated factor VIII as soon as possible. It also has a final paragraph entitled Reassurance, which includes the paternalist expression which Mr. Bowie referred to, that patients must continue to treat themselves with concentrates. This, of course, is a big part of the reason why those who received the letter thought they were uninfected. Why would this be good news as be portrayed to a patient if he were already infected? The clear inference was that they had dodged the bullet. However, sir, the position on the heat-treated concentrates was stated clearly and unequivocally. Mrs. Mackey, whose evidence is referred to by my learned friends, was aware that for this to be said with any scientific accuracy, it would have needed to have been tried on living patients. It was not until Dr. Foster gave evidence to this inquiry that it became apparent that it was in fact accepted at that time that that statement was not accurate, that it was not known that the heat treatment would be successful to destroy the virus because it had not yet been tested on living patients. That, sir, is the specific allegation, specific context of the allegation or the suggestion made by my learned friends about Mrs. Mackey's evidence. In my submission, she has not said that people were deliberately infected. However, she has said with some force and relevance that she and her husband and many others were quite reasonably driven to that conclusion. The specification with which she came up with the theory about the heat treatment trial, which she referred to in her evidence, was merely an expression of her belief that that may have happened. And in my submission, that belief was quite reasonable based on the assurances given in the letter. Sir, there is a detailed analysis in our submission of the various elements of research, which obviously I won't go into detail about today. That they are very important in my submission, both in understanding elements of the circumstances in which people became infected, but in understanding the attitude of indifference, it would seem, that treating clinicians appear to have had to what Dr. Ludlam described as useful material. I have also, sir, included in our submission details of other research beyond the research that I've talked about already, that being research related to liver dysfunction and hepatitis, the immune function research in both Edinburgh and Glasgow, and the ongoing research into the effects of AIDS on the Edinburgh cohort patients. I would draw your attention also, sir, to the fact that a number of family members of patients in Edinburgh also, it would appear, were involved in research. Both of the living members of the Edinburgh cohort have given clear evidence about the fact that wider family members, including those not genetically related to the infected person, had blood taken for research too. It seems that the useful material extended beyond the patients to their families. We would also draw your attention, sir, to the submission we have made about one AIDS case arising from the York Hill group, where, despite representation having been made to the hospital after the boy's death to the contrary effect, research on that boy continued even after he had died. Sir, my next section is entitled Compounding the Harms. In her oral statement, my learned friend Ms. Gray said that the evidence from the infected and affected of the impact heard by the inquiry spoke for itself. Mr. Corey Wright described the harms caused and compounded as unimaginable, though we took them simply to mean that this was a formidable body of evidence which they did not seek to challenge. In our submission, some risks arise from the fact that this attitude is taken to that body of evidence of which we would like to make the inquiry aware. We have a detailed section in our submission, which is section D, which we have entitled Impact. Although, sir, this may not need to be said, we think that it is an essential part of the inquiry's function that its report should undertake a detailed analysis of the consequences of the disaster for the infected and affected, detailing the depth, the variety and intensity of the harms, the breadth, the number and variety of people whom it has affected, of the damage which it has done. Some inquiries, such as the Scottish Child Abuse Inquiry, contain in their terms of reference a specific requirement that the inquiry create a public record of the harms. Sir, we would urge you to do the same. The failure of the state ever to undertake a proper assessment of the harm, need or loss of the community was a recurring feature of the evidence. Your report, sir, can remedy that at a community level. In our submission, the variety and complexity of the harms require to be carefully analysed and documented as a basis for what should be taken to be the characteristic consequences of infection for the purposes of the compensation scheme which we propose you should recommend. It is also important, sir, that the known or understood to be acceptable effects of treatment for those conditions should be charted in the same way. That task, sir, I think will be considerably helped by the useful summaries given at the end of the expert group reports, in particular on hepatitis and HIV, where they have sought to undertake that task. Rather than simply replicating what they have said, I would simply refer you to that, sir, but also suggest that there are a number of additional areas which the inquiry might consider including in those lists, based on the extensive evidence from the infected and affected about consequences which they assert are associated either with infection or with treatment. Sir, there are a number of particular facets of the evidence of impact to which I'd like to make brief reference. First of all, as it arises particularly in the client group which I represent, it is important, in our view, to make a clear analysis in the report of the extensive and devastating impacts of hepatitis C infection. A number of my clients have for many years fought for recognition on an individual or collective basis of the full extent of the harms which this deadly virus has caused. The concept of mono-infection, which sometimes one sees, is not one which finds favour with my clients, given the propensity which this term has to lessen a full recognition of the extent of the damage which this terrible virus can cause, and its tendency to suggest that those who have hepatitis C and not HIV are in some perverse way the lucky ones. Similarly, sir, it is our submission that the inquiry has available to it a particularly important body of evidence. That is the evidence which was given by its psychosocial group. Although, sir, I've made reference to a number of important features arising out of the expert group's evidence, I think it's important to bring to your attention, sir, that the analysis of this group of the extent and effect of the psychological harms visited on a vulnerable community when they went to obtain their initial treatment was frankly exemplary and should be reflected in the report. The experience of listening to the evidence was of great cathartic effect for a number of my clients. One must remember, sir, that many clients, due to the very nature of the stigma and the harm suffered, lived for years in isolation, thinking they were the only ones who had been affected in this way. Many saw the expert group's analysis and recognised themselves in the classes of victim and the types of harm which were being described for the first time. The group's analysis of the severity of the impact on the affected community was also a model of clarity. In this regard, too, we would refer you, sir, to the importance of a clear exposition being given on the extensive effects of stigma on the infected and affected communities. In itself, stigma destroyed lives, in particular where it was meted out by the NHS or the state itself. It is important that we don't look at this simply as an add-on to the physical harms, as, to be frank, sometimes the law might. Sir Robert Francis recognised this in his report, creating a distinct head of damages for stigma and associated loss, which in our view was entirely appropriate. Sir, another theme to which I would simply wish to make brief reference is the theme of family. In our submission, family runs through the evidence which you have heard. You have heard, sir, from a number of witnesses for whom the joyous occasion of the birth of a child was subsequently impacted upon by the fact that transfusions received at that time caused horrible infection. You've heard, sir, how the celebration of new life would forever be associated with a disease, treatment for which consigned the individual concerned to living a life of infection rather than a life of joy. Sir, you heard evidence from one particular client of mine, Mrs. Fife, who heard that she received an infection on the day of the birth of her child. As a result of treatment she received from that infection, which caused an autoimmune reaction, she has had, after that point, to live her life effectively away from light. On the very day when life was created, light, the very essence of life itself, was taken away. You heard the familiar heartbreaking stories of mothers, unwittingly having been the genetic source of their son's haemophilia, did all they could to follow treatment regimes they were assured were best for their boys. You heard of the devastation when that treatment took the lives of the boys away, which they had hoped to improve. You heard from a father, Mr. McDougall, who still, 30 years after his son's death from AIDS, contracted at York Hill, cannot get to the end of a sentence without breaking down. Who would forget his emotional recollection of the visit to his son's boat, Butterfly 23, after his death, still festooned with decorations from his last birthday celebration? Family as it was meant to be, joyous celebration, tragically juxtaposed with family cruelly and unnecessarily taken away. The York Hill Parents Group, a dedicated collection of loving parents seeking to help their sons, went to funeral after funeral as the boys passed away from AIDS. You heard from infected people about the devastation arising from the hereditary nature of haemophilia. Infections ravaged families, brothers and uncles and nephews were infected together. Often a tragic window into one person's possible fate was the person standing next to him, or worse, being lowered into the ground. You heard stories of family lost through stigma and isolation. You heard from widows about the transformation and loss of their infected husbands. You heard from one individual, Mrs. A.D., who told the tale of her son having to put his father, another victim of AIDS, into a body bag as the undertaker would not touch him. You heard from one lady, Mrs. Batters, whose husband had been infected with HCV by transfusion, who in turn had been infected by him. He had died shortly before she gave evidence to the inquiry in 2019. You heard from a wife of a campaigner, Christine Norval, who was scarcely able to contemplate the possibility that this inquiry may bring closure to her family. You heard again and again, sir, that despite the ravages of infection, the thing which preyed on the minds of the infected the most was the impact that their infections, acquired through no fault on their own, had had on their loved ones, and above all else, the earth-shattering and lasting guilt which they felt about possibly, though unwittingly, having exposed their family to danger too. You heard from family members also subjected to research at the hands of the state alongside their infected loved ones. Sir, the story of family is at the very heart of the story of the disaster. Sir, we also have in our submission an extensive analysis of the way in which not only were harms caused by infection and treatment, but that those harms have been irrevocably and multiply compounded and increased by the way that the state has reacted. The compounding of the harms, sir, is one of the most important and unique factors of this disaster. The unique result of the evidence heard in our submission is that the infected and affected have, unlike victims of other medical disasters, suffered the consequences of multiple wrongful acts on the part of the state. Their complex physical and psychological injuries have been rendered all the more complex, a single indivisible mass of harms with various forces and loss all interacting with and compounding each other. We urge you, sir, to reflect the uniqueness and complexity of their situations as a result in your report. Please pay heed to this. Whatever the argument about the avoidability of infections or their sequelae, the entirety of what compounded the harms was completely avoidable. Now, I also, sir, as I've made reference to the psychosocial report, refer you to the evidence given by that group on the 25th of February 2020, in particular page 124, where Professor Weinman predominantly, and also Ms. Edwards, gave powerful evidence, not simply their own views, but based on literature, namely the Elder paper and the Southwick paper, which led Professor Weinman to give the following account of the impacts of the events that take place after medical disasters. He said, again, lack of accountability, a lack of explanation, lack of apology, all those sorts of things really emerged in that, meaning the papers. And the effects on people were 90% of people talked about serious emotional consequences and major financial impacts as a result of all that happening. And so the impacts were huge, absolutely huge. Ms. Edwards went on to describe that there were a number of significant behavioural consequences listed in the literature in that regard. Sir, we think that the compounding of the harms is a unique and important element of this disaster, which again, we anticipate you will wish to reflect in your report. The 8th section of my submission, sir, is entitled The Myth of Devolution. I have touched on a number of the matters which arise under this section already when I talked about the advantages available to the state in Scotland. It is important to understand in my submission, sir, that there were a number of decisions which were taken at the time when infections were occurring, which were based on the parameters which pertained to treatment and the balancing of risk out with Scotland, which were then simply adopted and imposed upon Scotland. For example, the inquiry heard evidence that though the licensing legislation provided for the Secretary of State for Scotland to be involved in licensing matters, the licensing system operated through Medicines Division in the Department of Health and was not separate for Scotland. Therefore, no separate consideration was given for the need for imported products to be licensed or used in Scotland. As I have outlined, separate considerations in that regard applied in Scotland. Imported products were unnecessary. The products were admitted to Scotland on the basis of non-Scottish considerations. Furthermore, sir, other decisions were regularly taken in Scotland on advice issued to government based on what one might describe as non-Scottish considerations. The UK HCDO advice, in particular the Bloom advice in May 1983, were based on the English position. Guidelines were issued as to treatment practices which were based on the limitations of the English system to be able to provide alternatives to commercial concentrate. Dr. Walford confirmed that there was little or no contact with other regional administrations, including the Scottish Office. As a result, no separate consideration of the Scottish position was undertaken at government level. Similarly, the failures to introduce surrogate testing, anti-HIV and anti-HCV testing, due to the perceived need to coordinate these matters with the rest of the UK, showed the fallacy of administrative devolution in healthcare in Scotland. Things were not analysed along Scottish lines. This is, in our written submission, we address and explain something which we've called the Cash dichotomy, the phenomenon of Professor Cash apparently taking contradictory positions on these matters. In our view, this was due to the inherent tension in his position. He knew that things could and should have been done in Scotland earlier, but felt the need to protect the inherently dysfunctional national system. He was the living embodiment of the contradiction at the heart of the system, a contradiction which rendered the system unnecessarily safe in Scotland. Furthermore, sir, there are a number of subsequent examples of Scottish considerations not being looked at and the English position simply being imposed. You will remember, sir, the correspondence which took place as a result of a solicitor acting for a number of HIV patients in Scotland, Mr. Tyler, having written to the then Secretary of State for Scotland, questioning why it was that there had been an announcement that the HIV litigation was to be settled across the UK without there having been any consultation whatsoever with him or his clients. The evidence showed that not only had there been no consultation with Mr. Tyler, there had been no consultation with the Secretary of State for Scotland either. As a result of that, and the inquiry of course has looked at the detailed circumstances in which the HIV litigation came to be settled in England, the multiple litigations in Scotland, which of course were conducted on a completely different basis because the Scottish system was different, were not considered, and the HIV litigation settlement was foisted upon the individuals who were litigants in Scotland. Just another example of what we call the myth of devolution. Sir, we refer in our submission that the HIV litigation is, of course, a matter of some importance in its own regard. However, in our submission, sir, the HIV litigation marks an important moment in the history of the disaster for reasons other than its own intrinsic significance. You have heard significant evidence, sir, about the groupthink which emerged within government both at Westminster and within the Scottish office, and subsequently in the Scottish Government or the Scottish Executive after devolution. That groupthink has its origins somewhere. The thought which becomes the adopted position through a gradual process in our submission started at the time of the HIV litigation. We have referred the inquiry to a number of meetings which took place in 1989 and 1990. One is from the 16th of June 1989, the reference PRSE 0002656. The other is the 12th of February 1990, HCDO 40271_014. You will remember these meetings, sir. They caught our attention because although they are both, the first is a meeting of the UK HCDO directors, the second a meeting of the UK HCDO AIDS subgroup, both involve a particularly Scottish component. Doctors Ludlam and Lowe, and indeed certain medical advisors from Scotland are involved considerably in the discussions. It is important, sir, that you take some time to consider the content of these meetings, because in our submission, they are the origin of the groupthink which set in and about which you have heard so much evidence. The doctors effectively got together, came up with what we have described as the party lines. They were shared with government. Government attended both of those meetings, and in our submission, that is where one finds the origin of what the Lee Day representatives have described of the defensiveness which we have also set out in our submission. Sir, there is in our submission also a detailed examination of the period after devolution. It is important in our submission that you take time to consider in some detail the Scottish Executive investigation which took place in 1999 and 2000. Susan Deakin, in her evidence, then Scottish Health Minister in that administration, explained how, at the time of devolution, there was a new hope that things would be able to be done differently. She made it quite clear that advice had been tendered to her by civil servants consistent with the government line which had existed in Westminster and within the Scottish office. She explained that she was not prepared to accept that advice, and that the prima facie evidence available to her suggested this was a matter that needed to be looked at further, and so she did so and ordered an investigation. Our position, sir, is that that internal inquiry, which was prompted by two petitions that were lodged within the Scottish Parliament, one of which is entitled Petition PE 45, which asked for a public inquiry and for compensation for haemophilia victims of the disaster. That inquiry, sir, was completely defective. Despite their request having been for a public inquiry, instead the internal inquiry focused on negligence for some reason, which was a matter for the courts and not the moral responsibility and failings of the state, which a public inquiry would have done. The internal inquiry did not address anything like the number of questions which campaigners had posed, which a public inquiry could have done. The internal inquiry ran into trouble when the complexity and multiplicities of the questions raised by the disaster became apparent, which a public inquiry could have coped with. The internal inquiry failed to engage with the evidence or the allegations of the infected and affected in anything more than a cursory fashion, which a public inquiry could have done. Most of all, sir, that investigation was not independent, which a public inquiry would have been. We go into some detail in that regard, sir, about the fact that it was run by Dr. Aileen Keel, from whom the inquiry heard evidence. She was herself a previous haemophilia clinician who explained that she had been involved in the treatment, amongst other places, of the boys at York Hill at the time they were being infected with AIDS. She was, of course, also a civil servant who had been tainted by the party line, which had been the very party line that Susan Deakin had said she was so keen to resist. In the end, it is not surprising, in our view, that many of the questions which were posed within the investigation were found to have proven no negligence, when the source of evidence which was looked at was predominantly the very people within the medical fraternity whose actions were being criticised. We go into some detail in that regard as well. Sir, if I may simply again take you to one further document, I won't put it up to save time. The reference is SCGV 40170_152. And again, for the sake of clarity, actually, with this one, I think it might actually be worth putting it up because it's slightly difficult to follow some of the text. Just to explain the background, sir, this is a memo on behalf of the First Minister of Scotland, then Donald Dewar, written, we think, by a civil servant to Ms. Falconer, who the evidence, no, sorry, I don't think that's the right reference. Sorry, I've given you the wrong reference there. It's SCGV 40170_152. Sorry. No, that's RLIT. That's got RLIT. Sir, in order not to waste any more time, I'll simply do as I originally proposed, which is simply read out. This is a...
We better take this down, I think, because it may as well come off the screen.
Yes, indeed. Thank you. This is a memo, sir, written by Ms. Jackson on behalf of the First Minister, dated the 23rd of September 1999, to Ms. Falconer, who was one of the civil servants who was involved in conducting the investigation, copied to a number of others who were involved, including Dr. Keel. It's entitled Haemophiliacs with Hepatitis C, the Way Forward Following the Meeting with the Haemophilia Society. The context, you'll remember, sir, was that a meeting had taken place with the Minister shortly before this time, and that the broad questions that might be addressed had been laid out.
Remind me of the date.
The date of this is the 23rd of September 1999.
Thank
you. What it says is, the First Minister has seen your minute of the 17th of September to the Minister for Health, outlining a way forward following the meeting with the Haemophilia Society. He was a little concerned about the possible financial implications and fears that an open mind could be taken to mean an open chequebook. He would be grateful for information on the likely exposure if compensation were to be awarded. And the reason why I was going to put this up, sir, is that it's a slightly unusual document, and it contains what looks like a sticky label where it is what is written there says, some old papers from FM's office, interesting to see the wheels of decision-making in private office. But there's also another handwritten annotation on the document which says, Ms. Deacon's office advises that this is very much a PR exercise and there is unlikely to be any compensation paid. Sir, for once, I'm not sure I really have anything I can add to the text that I've read out, which I think is fairly self-explanatory. Sir, even in the period after the investigation, we have set out in our submission that the overriding control of the Westminster Civil Service and the fixed attitude based on the HIV litigation principles continued into the period after the internal investigation, a period in which Malcolm Chisholm was the Health Minister. In our submission, he was politically pressured into offering some level of compensation, but departed radically from the recommendations of the Ross Committee, which he had set up. Even his modest offering was reacted to furiously, it would appear, by the then UK Health Minister, Alan Milburn. By the time Lord Reid took over, the political die was cast, but he ensured that Westminster took control of the Skipton Fund. He said in his evidence on the 21st of July 2022 at page 15 that you can see from the papers that there is a suspicion on the part of some officials, particularly in the Treasury, that we don't want the Scottish tail wagging, you know, the English dog, as it were. The key was to ensure that Scotland would not bow to political pressure from the petitions, which were still live, and the Health Committee to go further and implement the Ross recommendations for compensation. One might describe that eventuality as being the operation of the local democratic process, i.e. what devolution had been all about. The culmination of this process was a loss of local control for the Scots, and years of reversion to the pre-Skipton position. Still not listening to the patients, still no assessment of the needs or losses of the community, still no examination of anything like the full range of the issues arising in Scotland. In addition, sir, the inquiry has evidence that HCV litigations, based on the similar parameters to the A against National Blood Authority decision, were settled for paltry sums, which it appears could not possibly have represented the full loss. None of them, as far as we understand, were settled on a provisional basis, which is my reading of it specifically provided for in one of the short procedural elements of the A decision. It was, of course, known at that time that the disease could become much more serious in future, and therefore, in dealing with the possibility that that might happen, and in accordance with the instruction of the then Health Minister to settle the matters fairly, it would, in my submission, have been appropriate for that to have been the basis upon which the cases could have settled, which would have been a competent way of proceeding in Scotland. Sir, I move on now to my 9th section, which is the solutions. As with others, sir, who have spoken on the infected and affected side, we have a lengthy list of proposed non-financial recommendations. I do not intend to go through these today, although I do note that these, as I've said already, have been considered by the Scottish state bodies, and in relation to those, they have issued a number of favourable responses, which we find encouraging. We would say, however, sir, that it is important that the general acceptance of the principles which we have proposed in a number of areas should not be taken to encourage you, sir, not to make the recommendations, if you agree with us, that certain steps need to be taken. We have outlined, as I think others have too, that we accept that it would not be possible for you, sir, to devise, for example, a new system of palliative care for liver disease in Scotland. If you agree with us that that is something which the evidence shows should be looked at, the way in which we would suggest you proceed on that and other matters is as follows. A general recommendation to that effect could be made, and I note the Scottish Government in particular seems to accept that that would be something in which they would certainly wish to become engaged. We have recommended that a task force be set up in order to monitor compliance with that general aspiration, and to have more discussions about practical matters that will, of course, have to be attended to about how that matter is dealt with in Scotland. You will note, sir, which I think was mentioned by my honourable friend Mr Johnson, that we have, with regard to the specific recommendation about palliative care, suggested that rather than that matter be dealt with fully by the task force, which will monitor its progress in due course, that a specific short life working group should be set up. This is following the model which happened after the Penrose inquiry, when a similar group was set up to have some initial thinking about how its one recommendation would be implemented. In our submission, this would be relevant in relation to the area of palliative care, because although the commitment made by the Scottish Government is a general one in that area, there are, as we set out in a submission, a number of important specific matters which arise in relation to end-stage liver disease, which merit separate consideration. That's the reason why that has been put forward. We, sir, have also set out in our submission that it is important that there be a fulsome apology. The reasons for that, I think, are apparent, again, in the evidence which you can see, sir, in the psychosocial group report, and indeed the evidence they gave to the inquiry, where they talk about the importance of a proper and fulsome apology being made. I recognise, sir, towards the beginning of my oral statement, that in this regard, although limited to being made on a corporate basis, those apologies made by the Scottish NHS are a model of the type of thing that the psychosocial group suggested would have a real impact in allowing people to come to terms with the harms which they have suffered. That is not the case, I should say, on the part of others. That has been addressed, of course, with regard to the Department of Health by other speakers. Equally, sir, I should draw to your attention that although the Scottish Government made a general apology and reiterated the apology made by the First Minister at the end of the Penrose inquiry, that the apology which, in general terms, we have sought from them relates predominantly to the matters I've just been discussing in the period after devolution. None of those matters were part of the terms of reference of the Penrose inquiry, although they are, of course, part of the terms of reference of this inquiry. Therefore, on that one matter, I think it cannot be taken to be the case that the Scottish Government could at that time have been apologising in the context of the Penrose inquiry for matters that it did not look at. The general nature of the apology gives no indication that that was the case. As a result, sir, I draw your attention to the broad but specific ways in which we would suggest that you invite what I would describe as proper apologies to be made on behalf of government. I have, sir, in our submission, spent quite a lot of time dealing with what one might call the financial solution. I would like to make clear, sir, one point which I think is important. You asked us to address in our written submissions matters of importance to our clients. Although, of course, the possibility of a Robert Francis-style compensation arrangement is of importance to all the infected and affected, I would like to make clear that it was not the instigation of my clients that we dedicated so much time to it. I think, in reality, sir, you will see from their evidence that none of my clients suggested that why they engaged with this inquiry was out of any financial motive. The reason why we have devoted so much time to it is that, as it happens, the area of reparation is one in which I am a learned junior practice, and therefore we thought that we could, in particular in light of the fact that there were a number of Scots law considerations, be of some assistance to you, and I certainly hope that's the case. We have, sir, approached this on the basis that in order to understand why Sir Robert Francis has come to the conclusions which he has reached, it is important to undertake an analysis of the principles which underpin his solution. We broadly agree with his solution. However, there are a number of areas in which, as a result of the limitations of his investigation, which he set out and readily accepted, he has not gone far enough, we say, and that there are elements of the financial compensation scheme which should be incorporated based on the evidence, the much fuller evidence to which you, sir, have had access. There are a number of points which I would like to make in a very general sense about this. The first is, sir, in particular based on the failure of the government to be able to provide a response to Mr. Snowden's question about their intentions with regard to compensation. We, like Ms. Gollop's clients, have become concerned about the government's ability to deliver compensation, as she put it. The one difference between her clients and mine, on the face of what she said, is that the scepticism which she described as having arisen in the last couple of weeks has been a scepticism which, in my submission, quite reasonably, has existed within my clients for a matter of decades. This is because, sir, despite the fact that a number of clinicians suggested that compensation be awarded in Scotland in the late 1990s, and an independent committee, the Ross Committee, which reported 20 years ago, recommended compensation for HCV cases which had reached stage 2 liver disease and damages equivalent to those which would be available to be paid in Scotland in fatal cases where negligence had caused the death. No compensation has been awarded in Scotland. The medical consequences of infection have, of course, moved on since then. The stage 1, stage 2 classification from Skipton has become slightly outdated. However, in my submission, sir, this has an important practical consequence. Our position is that as a result of that scepticism, we invite you, sir, to try to express a view specifically on as many elements of the compensation scheme as you feel appropriate. We have sought in our submission to try to provide you with our assistance on the way in which matters which, under Robert Francis' scheme, would be left to his medical and legal panels, could, in our view, be adjudicated upon by you. That would have a number of advantages. It would mean that the person who has been sitting for a number of years hearing all the evidence would be the person making the decisions, for example, about appropriate levels of compensation, at least in certain cases. It would speed up the process, which of course was a concern of Robert Francis and one which you yourself expressed, sir, in the interim report awarding interim compensation. It also, sir, would to an extent allay my client's scepticism that if this matter is left in the hands of government, compensation, despite the recommendations which have been made, like at the time of the Ross Committee, will simply not happen. As a result of our Scots law assessment, sir, we think that there are a number of areas where it would be possible for you to come to specific figures which should be awarded for certain categories. If you are not able to do that or don't feel that that would be appropriate, sir, some indication of the parameters, either in terms of the way in which damages might be calculated or indeed how much might be awarded, would, in our view, be helpful. As you will see, sir, we have presented an analysis which is based on the principles of Scots law and the principle of parity, which was favoured by Sir Robert. Though the harms arose across the UK in different ways, we think that the harms are comparable and that there should be parity across the UK. Sir Robert agreed, and in his evidence, we understood him to be saying that one of the purposes of a compensation tribunal was to try to keep matters based on past history away from the courts. The need for swift justice and finality, and the need to have a system whereby patients could buy in to the way things were being dealt with, all meant that it would be appropriate to keep matters away from the courts and litigation, which would inevitably be lengthy, costly, and in many respects not suitable, as the evidence of previous litigations has shown. If it is correct, sir, that Sir Robert suggested that we wish to keep matters out of the courts, and that therefore, in his assessment, which we agree with, awards should be commensurate with court awards for compensation, with certain bespoke elements relevant to this community that perhaps are not appropriate for the common law at large. It would, in our submission, be logical, sir, that those should be fixed in accordance with Scots law principles. The reason for that, sir, is set out in the helpful opinion which you have received from Mr. Milligan, KC, which is entitled, which is under the reference INQ 40416. What that points out, sir, is a number of important features, the result of which is that Scots law, in particular in the area of fatal claims, although also in other areas such as interest on past losses, Scots law would take a different approach from the way that Sir Robert Francis set out a report based on English principles. Our position, as I've stated, sir, is that the tariffs should be fixed for the reasons I've set out, and that the tariffs should be fixed in accordance with these Scots law numbers. The tariffs, in particular in fatal cases, would be greatly assisted in my submission by the fact that although we don't have a tariff-based system for the award of damages under the Damages Scotland Act 2011 in fatal cases, it would be fair to say, as Mr. Milligan reflects in his helpful report, that there are quite narrow parameters in which awards tend to be made to different classes of claimant. I was asked to look at the Milligan report, sir, and report if there were any matters on which I took issue. Mr. Milligan's undoubted expertise in this area means that there are only a few matters which I have to mention, which I hope are of assistance. At paragraph 49 of his report, he attributes, in fact, higher figures for what he calls loss of society. That is actually a slightly outdated figure than I have submitted in my analysis. Of course, I take no issue with his figures. I would draw attention, sir, to the very recent case of Patterson and others against Lanarkshire Health Board, which is reported under the neutral citation 2003 CSOH1, a decision of the 6th of January of this year of Lord Arthurson, which does seem to support a recent upward trend in awards. In that fatal case, £70,000 was awarded to the children of the deceased, now adults, which I think is the highest such award to such a category, and £100,000 was awarded to the deceased's mother, which again is a higher figure than the one which I allocated in my submission, but is commensurate with the figures suggested by Mr Milligan. Furthermore, sir, his commentary on the law related to mitigation of loss appear particularly apposite here, the law requiring that not be judged too finely on the basis that such criticism does not come well for those who themselves have created the emergency. He also, sir, at page 9, draws attention to the fact that the use of half-rate interest would, as I have submitted, in a court, require to take account of the fact that different judicial rates of interest would apply in the period over which loss has been suffered by the community here. Therefore, my suggestion that the half rate of interest, which would be applied currently of 4%, is already a compromise based on the fact that rates that would have been used in previous years, where interest rates were higher, might result in a higher figure being used. Other than that, sir, I suggest that the report is extremely helpful in setting out some of these principles, and I think accords with the assessment we have made of what you should do. In this regard, sir, there's one other matter which I would like to mention. That is the submission which has been made on behalf of the Scottish Government relating to whether or not past payments under the various trusts and schemes should be taken into account in the assessment of compensation. Broadly speaking, sir, we disagree that that would be appropriate, and we share the view of Sir Robert that the way in which those payments should be characterised is payments which have been made to alleviate poverty and are of a benevolent nature. This is consistent with the evidence which you have heard, sir. Indeed, the evidence that was given by the then Minister, Ms Goujon, on the 18th of May 2021 at page 36, confirms that it was her position that previous payments had not been intended to be compensatory. Furthermore, in my submission, sir, the characterisation which Sir Robert places on the previous payments is consistent with other evidence heard by others who have been involved in the administration of schemes, in particular Mr Lister, who gave evidence on the Caxton Foundation payments. He said that the purpose of those was to lift people out of poverty, poverty which in many cases was created by state culpability leading to infection. In my submission, again, that is consistent with the analysis. Therefore, sir, we do not agree with Mr Johnson's approach, and indeed we found it slightly surprising, or those whom I represent did, that the Scottish Government should seek to take such a position, in particular in circumstances where they agree, as I think everyone does, although perhaps for slightly different reasons, that the money should be paid from the UK government's funds on the basis that the original infections were all caused before devolution, or at least that's the argument that myself, Ms Gollop, and indeed Mr Johnson propose. There are a number of other arguments, sir, which we don't think are ones that you should accept. An argument was made about fairness based on the fact that people have received variable amounts in the past. I understood Mr Johnson to accept that it would only be payments which could be classed as compensatory which fall to be deducted, but he offered no means of understanding what type of payments would fall to be characterised that way. Furthermore, sir, our submission is that the concern that he had that there were people, I think, who may not have received compensation under the scheme who should have done, might be disadvantaged, it is not well founded. I think it must be the Scottish Government's position that those who are due to receive support have received it, in particular because he explained that extensive efforts had been made to trace untraced transfusion infections with HCV after the Penrose recommendation. Therefore, it is, I think, the position that if anyone has received less than they should have done in the past, such that such unfairness in his submission may arise, that in our submission would logically be dealt with by a back payment of support rather than everyone falling foul of this rule which is being proposed. Sir, I don't intend to go into, to any extent, any of the other recommendations. They are numerous, but I would urge you, sir, to make recommendations on this basis. It is one thing which I should mention, sir, is that we do associate ourselves with the general position of the Scottish Government in this regard. They have indicated a willingness and indeed a desire to continue to control at least the Scottish Infected Blood Support Scheme. There may be some suggestion made by others that the administration of those schemes should change. We support them in that on the basis that local accountability and local administration is something which is of certainly considerable importance and value to my clients. Could I just, as far as non-financial recommendations, sir, point out that I've provided the inquiry a few days ago with an article which appeared in the Daily Record, which I think neatly set out the Scottish position on what might broadly be described as the Hillsborough Law. There is a current controversy in Scotland about this, which has arisen between the Labour opposition and the government. I simply wish to refer that to you, sir, because it may well be, as others have done, that you wish to make recommendations which fall in that general area. And I thought it would be useful for you to be aware of the fact that there is certain controversy. The basic position is that the government has rather set its face against a number of the recommendations which are made and which are being so passionately supported by Mr. Burnham. They do so in part on a technical distinction between there being some difference between fatal accident inquiries in Scotland and coroner's inquests in England. My position would be that substantively there is no difference between the two, and that the difficulties which the Scottish Government seem to have with it are not well founded. Sir, in concluding, I wish to make brief, though important, reference to the dedicated work of you and your team. May I also pay particular tribute to the council team. In my humble submission, they are deserving of the highest praise, not only for their professionalism and dedication, but also for the compassion, courtesy and humanity in which they have handled both their professional duties and their personal interactions with the infected and affected. Compassion, courtesy and humanity which they have always deserved but far too seldom encountered in their previous dealings with authority. If I may, sir, be so bold as to say that in these personal interactions, the approach has mirrored entirely the approach which you and your staff have taken in all of your dealings with those whom I represent. In that regard and in many others, they wish to pass on their profound gratitude. Sir, may I also pay tribute to the dignity, courage and responsibility which my clients have shown in their dealings with this inquiry. From amongst my client group, may I pay particular tribute to the fearlessness and responsibility of Bill Wright, the intelligence and doggedness of Alice Mackey, the scepticism and ferocity of Bruce Norval, and the courage of the late Philip Dolan. They fought on in the face of government intransigence to the plight of the infected and affected community, as appears to be recognised in so many of the submissions received by the inquiry. In doing so, they suffered incalculable further harm to themselves and their families. It has been a particular privilege to have acted on behalf of those courageous individuals who have spoken for so many others so selflessly for so many years, and others in the community which they represent. It has been an honour, sir, to speak for those who, through the culpability of the state, are not able to speak for themselves. Sir, here where the words end, those whom I represent put their fate in your hands. They do so willingly. They do so with faith that you will complete your task with compassion and humanity. They do so with, for the first time for many, some hope for the future. They do so with clarity about what was needlessly done to them by the state. I leave you, sir, with a short video presentation, My Clients, the Infected and Affected of Scotland.
And I ask you as lawyers, particularly those of you who are here on behalf of government, to go home today and examine your consciences and reach deep down into your very personal souls. I don't believe you're bad people, but you are people who advise. And you need to advise with compassion and humanity. So, sir, I stand, we all stand, and we will continue to do so until this matter's resolved. I thank you.
Play cards by candlelight. I love the way your mind dances. But shuffle in this time. Give yourself half a chance. Spending time getting to know you. And I find falling through. Head in sunshine, I'm bathing your light. A little shy sometime, but that's okay. The flowers are blossoming and the summer is coming. Holding on through today. Spending time getting to know you. And I find falling through. Oh, hurts and harms. Precious and delicious, I savor the sweetness. A bird in a hole and a fire in a home. So fly on, my precious, cautious one. Spending time getting to know you. And I find falling through. Oh, hurts and harms. Falling through. Playing cards by candlelight. I love the way your mind dances. But shuffle in this time. Give yourself half a chance. Spending time getting to know you. And I find falling through. Head in sunshine, I'm bathing your light. A little shy sometime, but that's okay. The flowers are blossoming and the summer is coming. Holding on through today. The flowers are blossoming and the summer is coming. Holding on through today.
Thank you very much. If I can change the mood a little. You mustn't apologise too much for the length of your submissions. I know it's longer than a Walter Scott novel. But when I was educated in Scotland, I do remember my teacher telling me that there had been at least one sentence that Sir Walter Scott wrote, which lasted for 28 pages. And yet, you can see the esteem in which he is held. I found what you wrote lengthy, certainly, but very helpful. Thank you very much.
Thank you, sir.
So just to say, tomorrow is the final day of our submissions. We will be hearing from Mr. Steen in the morning on behalf of the core participants represented by Milner's Solicitors, and then from me at 2 o'clock.
So tomorrow, 10 o'clock.